that students do not lose their constitutional rights when they enter the schoolhouse gates. However, because of the nature of school and the nature of the activity of school and the need for there to be an orderly educational process, Tinker envisioned a framework where there could be exceptions, just as there can be in the workplace.
Mm-hmm. And Judge Roberts, in the majority opinion, in the very beginning of his court opinion, as you know, very specifically talks about the Tinker decision that students don't shed their constitutional rights of freedom of speech or expression at the schoolhouse gate. My question would be, with respect to the Tinker standard, that events at school should not cause a material and substantial disruption, what exceptions, if any, would you make to students' freedom of expression in the classroom and actually at school?
Well, I felt that the Juneau School District, which had gone through a very careful process of evaluating student speech and then articulating in writing that policy. So this is not a standard list, kind of call it the way you see it, call balls, call strikes, but it's a very careful written policy. And that policy, as I mentioned before, anticipated and encouraged an atmosphere of robust discussion and robust debate. But I do think that the categories that have been created under the existing framework of American constitutional law, the jurisprudence of the Supreme Court, is a sound and workable one. I may be the only voice at the conference that does articulate that view, but I think the Supreme Court has basically gotten it right in each of the cases that the conference will be discussing, including in the Tinker case itself, that there was no showing of material or substantial disruption. And I think that's the key. And that does mean that there's going to be some discretion exercised by the school officials. And so, yes, there are certain categories that will be disrupted by their very nature. That doesn't mean that some issues aren't going to be very difficult and very delicate, especially when we're talking about T-shirts with messages that are sort of exclusionary or viewed as, if not physically threatening to human dignity. There'll be a lot of, I think, litigation in the future about that. But I think the Tinker framework is a very useful, practical framework that says yes to student speech, but that there are exceptions, such as drugs, alcohol, tobacco, threats of violence and the like.
You know, when you and I and John Tinker and our friend Howard Bolting did the telephone interview several years ago, I think even John Tinker was surprised that you spoke favorably of the original Tinker decision, didn't you?
Yeah, I think that was John's reaction, and obviously the Tinker decision has come under enormous criticism by very thoughtful people, and of course it prompted a dissent at the time by a great friend of the First Amendment, Hugo Black. We see concerns on the part of Justice Alito and Justice Kennedy in their concurring opinion in the Morse v. Frederick case about granting too much discretion to school officials. That's on the one hand. Then you see Justice Thomas in his concurring opinion sort of echoing Justice Black's dissent. Who's in charge anyway of our schools? Is it the schools and Deborah Morse the principal, or is it the students? And it sounds obviously like a rhetorical question, but it's the kind of question that both Justice Black at the time, Justice Thomas more recently asked. But I think, again, that Tinker got it exactly right. There should be a baseline of freedom, and then there really is, and what that ends up doing is putting the burden on the school to justify the departure from the baseline and say, no, you cannot, in fact, engage in that kind of speech. I think that's the right kind of framework, but a lot of people just don't agree with that at all.
During the oral arguments in the Morse v. Frederick case back in March of 2007, Justice Ruth Bader Ginsburg asked you if that banner had said "Bong stinks for Jesus," was her change of the banner. If that would be more permissible and therefore be a protected right under the Tinker standard, and therefore not promoting drugs. How did you respond to her question?
Not very well, and not very persuasively. I don't think I
That's why I asked you the question.
Thanks a lot. I'll see if I can do better a few years later, but I doubt it. You know, there are a whole host of hypotheticals, and I thought that the particular hypothetical, so perhaps what I should have said is that message seems to me, again, in the same categorization that Joseph Frederick gave his own message of Bong Hits for Jesus, namely that it's nonsense, that it's trying to get attention. So the question would be, did Deborah Morse, if that were the message, did she act reasonably under the circumstances? And I would answer this, yes, she did, because of the key Bong Hits. If you're using Bong Hits, why are you using that well-known, drug culture kind of term? It can't be that you're talking about Plato, Aristotle, or the Olympic torch. So I would say a common sense interpretation, even though it strikes me as the majority opinion put it in one respect that it's gibberish, it sounds even more in the nature of gibberish, but it nonetheless should be interpreted, or could reasonably interpreted by the principal as promoting drug use.
Sure. Before we wrap things up, let me ask you a question, and that is, why do you think the Tinker decision itself has stood up for 43 years the way it has?
I think it is deeply rooted in the American culture of liberty, that we believe fervently that the Constitution, the Bill of Rights, and then all of the supervening amendments, but most importantly the 14th Amendment, in extending, as interpreted by the courts, these precious freedoms to all persons as against the states, and of course against local school districts for that matter, just strikes the American balance exactly right. It's deeply rooted in our culture of freedom, but at the same time I think it shows a dose of, shall I say, common sense and awareness of context. The context is so important. So just as Holmes famously said, the freedom of speech does not include yelling fire in a crowded theater. Well, why is that? They're words, but it's words that can do what? Can inflict enormous social harm. What's the good that's coming out of it, and so forth. Well, a public theater is frankly even more of a place of freedom, it seems to me, than is a school where there is, a public school, where there is an in loco parentis kind of dimension, that we entrust our children, or our grandchildren in my case, to the schools, and we expect that environment to be a safe, learning environment. And those things which detract from it and satisfy the Tinker standard, which is a demanding standard, are then those that just said, talk about Bong Hits when you're off school grounds. When you're down, there was a wonderful delicatessen just about a block and a half away, which is a popular hangout for the kids at the high school. Just go there and talk about legalizing marijuana or Bong Hits or whatever you want to talk about, but just don't bring that onto the schoolhouse grounds where people want. And by the way, there was a serious drug problem in Juneau which gave rise to this concern about speech that would be promoting the use either of drugs or tobacco. And this is just a public health and safety kind of concern that I think Tinker allowed for the consideration of these various factors and say, please wear your button, your anti-Vietnam War button, John and Mary Beth Tinker. You're at liberty to wear that button, or to wear the armband, as the case may be. Whatever you want to say, you presumably have the right to say it unless we can demonstrate, we the school, that this is going to be materially disruptive to our educational function. I think that's why it stood the test of time.
Judge Starr, the use of the internet, cyber law, and issues related to freedom of speech and expression are certainly going to land in the laps of our courts more and more. As president of a major university, what legal challenges do you see these bringing into the public and private educational arenas right now?
Well, I don't have a very good crystal ball to see what may come, but when we try to look into my cloudy crystal ball, what I see is this. We don't know what technological changes are going to bring, but what we do know is that first principles remain the same in a free society. So I would just encourage administrators, counsel to the schools, and so to always return to home base. And that is, what are those first principles? And I think that's what the Tinker framework gives us. Now, again, the Tinker framework is under some tension, as we see from the myriad opinions in Morse v. Frederick. But until the Supreme Court makes it very clear that that is not the framework, I think as these new technologies give rise to new issues, return to that basic baseline: freedom, freedom unless you can prove substantial disruption. At least that's my thinking, without having made a study of it, as so many of the folks in this conference will have done and have continued to do.
Mm-hmm. Judge Ken Starr, thank you so much for taking your time and talking about the Morse v. Frederick case, as well as the Tinker decision. And as always, it's a pleasure talking with you, and